Ever pondered about the invisible boundaries in the vast expanse of the oceans? They exist and they're called maritime zones, a concept under the International Law of the Seas. This law is an intricate system that defines the rights and duties of nations concerning the world's oceans. Let's break it down. First up, we have territorial waters, the sea area extending up to 12 nautical miles from the baseline of a coastal state. Beyond that, we have the contiguous zone, extending another 12 nautical miles, where a state can exercise control to prevent infringement of its customs, fiscal, immigration, or sanitary laws. Then, there's the Exclusive Economic Zone, or EEZ, extending 200 nautical miles from the baseline. Here, a coastal state has special rights regarding exploration and use of marine resources. And finally, we have international waters, where no state holds jurisdiction. Now that we know the different zones, let's dive into the laws that govern these waters. Ever wondered when and how these laws came into existence? Let's dive into the historical depths of the Law of the Seas. The first major stride towards establishing a legal framework for the oceans was taken in 1956, with the inaugural United Nations Convention on the Law of the Sea, commonly known as UNCLOS. This initial convention was a historic moment, sparking a global conversation on maritime rights and responsibilities. But the laws of the seas, much like the oceans themselves, were not to remain stagnant. Over the decades, the UNCLOS underwent significant transformations, adapting to the ever-changing geopolitical currents. Fast forward to 1982, a landmark year in maritime law. A revised UNCLOS was adopted, which we recognize today as the contemporary Constitution for the Oceans. This intricate legal document, with its intricate balances of rights and responsibilities, is still in effect today. As these laws evolved, so did their implications on the world. How do these laws manifest in real-world scenarios? A great question, and one we'll dive into now. Let's start with the Arctic, where the impacts of climate change have led to new navigable waters in areas previously covered by ice. The Law of the Sea Convention, or UNCLOS, plays a significant role here. It helps to determine which nations have rights to these new routes and resources. For example, Russia and Canada have both made extensive claims to the Arctic seabed based on the principle that their continental shelves extend into this area. But what happens when these laws are ignored? Well, let's look at the South China Sea dispute. Here, China has claimed almost the entire sea, ignoring the exclusive economic zones of other nations as defined by UNCLOS. The result? Heightened tensions and territorial disputes that have the potential to escalate into conflict. And this is where the International Tribunal for the Law of the Sea, or ITLOS, comes into play. Established by UNCLOS, ITLOS serves as a court for maritime disputes. It interprets and applies the convention to ensure that the rule of law is maintained. One of its landmark cases involved the Enrica Lexie incident, where Italian Marines on a commercial oil tanker shot and killed 2 Indian fishermen, mistaking them for pirates. The tribunal had to decide on complex issues of jurisdiction and immunity under international law. Ultimately, the tribunal ruled that Italy had jurisdiction over the Marines, but also held that India was entitled to compensation. Such cases demonstrate the complexities of the law of the sea. They show us that while the principles may be clear, their application can be anything but straightforward. The laws must navigate not just the physical geography of the world's oceans, but also the political and economic currents that flow beneath the surface. The law of the seas is a complex and dynamic field, with each case adding a new layer to its interpretation. It's a framework that constantly evolves, shaped by the push and pull of international relations, technological advancements, and the ever-present need for resources and security. Where are we headed with the law of the seas? As we venture into the future, the law of the seas faces a tide of challenges. Climate change, a force that spares no corner of the globe, is causing sea levels to rise, altering the very shape of our oceans and coastlines. This could lead to disputes over newly submerged lands and the shifting boundaries of territorial waters. Then there's the increasing competition for resources. As our population grows and technology advances, the sea's bounty becomes ever more enticing. Fisheries, oil, gas, minerals. The sea is rich with resources, and the law of the seas will be crucial in managing these riches and preventing conflicts. In the face of these challenges, the law of the seas will need to adapt and evolve. It will have to be flexible, yet firm, ensuring that the rights and responsibilities of nations are upheld, while protecting our precious marine ecosystems. As we continue to explore and exploit our oceans, the law of the seas will continue to play a key role in maintaining order and balance. So, what have we learned about the law of the seas? We've delved into the zones, from territorial waters to high seas, and how they're defined. We've journeyed through history, witnessing the birth and evolution of this intricate law. We've seen it in action, governing maritime disputes and protecting our oceans. And we've peered into the future, anticipating the challenges it may face. The law of the seas is a fascinating and complex field, and one that will continue to evolve as we navigate the uncharted waters of the future.